support us and to mold our thoughts as we pursue these final changes. In your name we pray. Amen.
Thank you, Member Gale. We'll move to apologies for absence, and we have apologies from Member Brea, Member Brown, Member Cuthbert Flynn, Member Brown-Burke, and Member Morgan. All right, so we move to welcome and opening remarks. Welcome everyone to another session of the Joint Select Committee on the Jamaica Teaching Council Bill. I want to also welcome some parliamentary interns that we have online this morning. Welcome to Mr. Asaju Brown, Mr. Shaquille Nemhard, Ms. Amoya McLeish, and Ms. Suzette Ray. I hope you find the session enlightening and intellectually stimulating. And with that, we will move to the confirmation of the minutes of the meeting held on Thursday, October 5, 2023. We will move to page 1. Page 2. Page 3. Please go ahead.
Good morning, Chair and members, colleagues on the platform. I have noted that for the third paragraph on page 3, the information in bold at the end for the avoidance of doubt, a disclosure that is made in person shall be, the word made is to be inserted, shall be made in writing within 3 to 5 days of the disclosure. Thank you.
Thank you. Page 4. Page 5. Page 6. Page 7. All right, there being no other correction, I ask for a member to move the acceptance of the minutes. Moved by Member Gale, seconded. All right, I'm not hearing our persons online, so I will defer the seconding of the minutes to the end of the meeting. Are there any matters arising from the minutes?
Yes, Chair. Thank you. I am aware that, recalling from the meeting, the last meeting, in relation to the matter of the police record, that the committee agreed that persons who apply to be registered or licensed as a teacher or apply for an authorization to teach should provide a police record. I took the matter into further consideration, and based on the length of the police record and the mechanisms that are currently in place under the bill, I am of the view that the police record is not necessary. I will explain. So the police record is used to capture the convictions of an individual. And under the Act, once a person is convicted of an offense based on the definition which we are supposed to finalize in terms of those acts that will be captured, the council will revoke the person's license or authorization to teach. Now, I'm thinking once that is in place, then the matter of conviction would not be an issue because it would trigger the council to act as against the police record, which serves for what, 6 months? It lasts 6 months or a year. If it is that upon registration or license of the teacher, that license lasts for 5 years, and so whenever you get the police record, then if you committed a crime within that 5 years of the license being reviewed, then it would not be captured until you would have applied for the renewal. However, if during that 5-year period the person commits an offense, then it would have already been triggered based on the mechanism under the Act for that person's license to be revoked. And on that basis, you would need to have a criminal record check because the person would have actually been out of the system because of the revocation. And so the mechanisms would have made provision for that. What I think is what you would need is for initial registration or licensing to ensure that before you enter the profession under the regime, then you can provide that that police record to ensure that your record is clear. But upon becoming in the regime under the bill, those mechanisms will allow for whatever conviction to be captured and the necessary action taken by the council.
Chairman, if I'm going to agree with those statements, I'd want us to use the latter part of the defense and not what was laid out with about the length of time. But the other arguments after that are very solid, but not the time it takes, because then we could have looked at putting in system. If the time was the issue, we could have looked at putting in systems to expedite the process. So let us not use the length of time as a defense. The other points that were made are very strong.
Okay, so, okay, all right. So my understanding of what we wanted is for all persons coming into the profession, right, to have a police record. Just so we're not taking in somebody who should not be taken in. Once they're in, right, and if something happens, then we have a process to deal with it once they're in the profession. Are we saying different things here? No, we're saying the same thing. So what is the
Minister, what you
change?
just articulated was the view I held as well, that that was the position of the majority of the group. But you would perhaps need us to hold on this vote since we don't have a lot of members present today. I wouldn't want those of us, the few of us who are present, to cast a vote in this regard. Maybe we would need to defer it.
So what we have here, Member Crawford, is that the committee, I'm reading from the minutes of the last meeting on page 6, almost to the bottom. It says the committee agreed that persons who apply to be registered or licensed or as teacher or apply for an authorization to teach should provide a public record, police record. So I'm not understanding, Mrs. Gordon-Jones, what is the change?
Minister,
Yeah.
I'm sorry?
I'm just saying, no, to our legal minds, I'm not seeing what needs to be changed in that sentence that I just read. The committee agreed that
so, Minister,
persons...
based on what you've just read from the minutes, that the committee is in agreement with the teachers having to seek the police record, and I suspect we need to stand by that decision then.
Right. These are persons who apply to be registered or licensed as a teacher or apply for an authorization to teach should provide a police record. So can you explain what it is that you're saying is different? Or Member Gale, you wanted to go ahead?
I wanted to seek some clarity because so in the first instance, there are persons now within the system. And let's clarify if those persons who are already in the system, upon seeking to be licensed or registered, would require a police record. That's the first thing that we need to clarify. And then now, there's always a renewal period. Are we suggesting, that upon the renewal period, you're also required to provide a police record? Because based on what Mrs. Gordon-Jones would have suggested, if there is a conviction for any of the offenses under the schedule that we are about to agree on, then that would disqualify a teacher from being within the system. So that would be the trigger, and there would be no need upon renewal of licensing or registration to provide another police record. I would have queried also on the same page 6 about the next renewal of persons already in the system. And it's about the fact that you have a police record for there's a lifespan to it. And so, Chair, at least a principal would have raised the concern with me if I get the police record. Do I need to keep applying for a police record? Okay, so that needs to be cleared in the mind of teachers, that it's not a situation where, like, your passport expires, you have to have a renewal. So we need to be very clear that it is for those persons who are now seeking in the first instance registration and licensing for the provision of the police record. Because it would not be prudent for this continuous application of renewals for police record, because the system would already have identified you if you are in breach. And so we don't need this blanket charge for those who are never in breach to be constantly providing a clearance of evidence that they are clean.
Okay. Member, I don't think that's what we are asking for at all. I like how you broke down the different categories. One, the persons who exist in the system now. We're saying once we transition to that regime, they should get a police record, right? But given that they're continuing in the system, there's no need for the renewal, because if something comes to the fore, we have a process with which right. New persons coming in obviously will need a police record as well. So I think we're agreed. Member Crawford?
My difficulty with the last part of what Member Gill said, Chairman, if we're going to ask that teachers have police record, the police record, it comes with an expiration. So it would mean if the teachers are doing a renewal and they're outside of the window, if they are in a period where the initial record is, the initial police record is needs to be renewed, it has expired, then I suggest they would need to have a new one, a police record.
Chair, because so this is not for the purpose like your usual your passport or visa to travel. That's a permit. The system, Member Crawford. So you present evidence that you have a clean bill of health in terms of your police record in the first instance. So, and this would be upon the application for registration and licensing. Now, your record would be tarnished if you would have been guilty of an offense under the schedules that we are about to agree on. And that would now trigger you being disqualified from the system. And so there's no need for proof or evidence of a police record to do so. That's my understanding.
I hear you, Member Gay, but I'm not quite sure if I'm in full agreement as yet. Because what if for our job we're required to produce a medical record, and then we later develop some complications, hypertension, for example, and the job that you're seeking, once you're hypertensive, you're not qualified for that job. So suppose at the time when I applied for the job, I didn't have any traces or any evidence that I'm hypertensive. Are you saying that that one-time record should stand? I don't, unless I'm not following.
In that case, an employer don't know you. And for the employer to be aware of you fully, the employer may want to require that you provide and ensure and satisfy that employer that you have a clean bill of health to pursue your duties. Now, if you become ill, it is no reason to prevent you from continuing your employment, because illnesses is not something that you go there and you pick off a shop shelf or you intently pursue it. That's a different matter. In this case, we're talking about a record in terms of your character, whether or not you have been convicted of an offense that we are going to agree on in the schedule. And what we are simply saying is that if for any reason you would be convicted of that offense, the system would automatically trigger a disqualification of you being part of the system.
That's true. That's correct.
Right.
The system would be able to. Okay.
Yes.
I'm on the page now.
And so,
thank you.
That is the reason why you don't need every defined period to be providing this evidence that you are, because what it does, what it would be doing is that
correct. It would become redundant.
It is that simply those who are clean from being convicted would be forced now to be providing this police record when it's unnecessary. It's unnecessary. And so we don't want teachers to be treated in a herd to capture with the evidence of a police record.
Chair, just to clarify for Member Crawford in terms of the length of the police record, it was not in terms of the application, it was in terms of the validity of the police record. And another thing, Chair, I think the understanding was once you are applying for your license or your authorization to teach, whether it's upon an initial licensing or a renewal, you will be required to provide that police record. So I think that was the understanding once you are applying for the license, whether it's an initial application or a renewal application.
Okay, thank you for that clarification.
And Chair, and another thing to also note, the renewal. So I said that I think the understanding was once you are either applying at an initial application or a renewal application, you would have been required to provide that police record. That was the understanding we got. But as I said before, once you do that initial application, you provide that record, and then the system, the mechanism under the legislation will capture any future convictions. And so you would not need to provide a police record upon renewal. But the other thing,
I now understand what you're saying and why you would have raised it, because of the trigger of the renewal. So I think we're clear, Chair.
Just to note, though, in terms of registration, those teachers who are already in the system under the current regime, they are going to be deemed registered, and so they would have to get the police record upon application for the license. But new persons, they would need to get it upon application of registration.
Bear with me, because you, Mrs. Gordon-Jones, would have identified steps in processes just now. And I want to be clear that those steps in processes are imprinted in the legislation where it can be clearly understood. Between the period, for those who are already in the system, that is going to be applying to be licensed, what is required and where that applies. And for those coming new into the system, that would have to register and pursue licensing. So we might, Chair, have the intentions of the application of the legislation, and we know the objectives that we are seeking to pursue in the legislation, but where it is documented and clear-cut, I just want to be satisfied that in the scheme of things, it presents itself.
The Chair would have to review those provisions to ensure that it is clear in the current dispensation. Because as it is now, 35(2)(b) says, in the case of a person who intends to teach in an early childhood institution, a consent signed by the applicant for the council to conduct a criminal record check on the applicant in connection with the application. I think this was where all of the discussions arose, to say that not only those persons in the early childhood institution, but all persons. So that clause would need to be revisited. And then you have the application for license. There is also a provision that asks for consent to conduct the criminal record check. So that would also have to be looked at, and the authorization to teach section clause 37 2B and the clause 38 2. So those clauses would have to be looked at to ensure that it goes in sync with what the committee is agreeing. $37 is for authorization to teach.
But 37(2)B, a consent signed by the applicant for the council to conduct a criminal record check. Now that is saying that I must ask you for you to
allow me
to go do the check.
But you cannot do the check on behalf of the person.
Right.
So that is something that we would have had to revisit based on.
But if the requirement is for the pursuance in the first instance for the evidence to be provided by me who wants to teach, then it creates the approach that we would want. So this would have to be looked at. You're right.
All right, members, just to be clear, we're looking at two different categories of persons. It would be the persons in the system currently, the teachers in the system currently, and then new teachers coming into the system. We're saying that for teachers already in the system, once we transition to, once this bill is passed and we transition, all the existing teachers will be considered registered. Automatically, they'll be considered registered. And so there's no need at that point for the police record until they apply for the license, and then they have to get a police record at that point. But that would be the only record, the only time they need to apply for the police license, because thereafter, if an offense is committed, there is an internal process, right, to interrogate and take action. Or for new teachers coming into the system, at the point of seeking registration, they have to seek a police record before they can move on to being licensed. No, they have to get the police record when they're seeking the registration, right? Right, and then right, but they get the police record before they apply for the license. Upon registration, okay. Upon registration. And having come into the system, they too will not need to apply again, because the same process will be applied to them as well if there is an action, there's a charge. And so. Member Gale? Member Crawford? Uh-oh. He can't. So I remember I think we're agreed on that. So I think we're clear on the steps and that we're being careful, but we're not overly burdening the system, given the process that we have outlined, the disciplinary process. All right. All right, we will continue. Any other matters arising? Okay, we'll move on to the next item, matters for discussion. Continuation of the clause-by-clause review. And we have 3 matters there, review of outstanding matters on JTC draft bill, Jamaica Teaching Council bill, redraft of clauses 60 to 85. Yeah, so please guide us, Mrs. Gordon-Jones.
Chair, where we were at the last meeting, based on my recollection, was the document that says some items for finalization to be taken by the Joint Select Committee. And the number 1 on that document was in relation to the police record. And that is now finalized based on the previous discussion. The second one was in relation to the terms, the paraprofessional, the teacher's aide, and teacher's assistant. That was treated with at the last meeting. And so the next one would be number 3, regarding the best interests of the child. I am not sure though, Chair, if we okay, I just checked the minutes. So we did finish all of number 2. So number 3 would be the discussion that the term best interests of the child does not cover and protect the interests of students who are 18 years and older. The committee agreed that a provision should be included in the bill which references Section 2 of the Child Care and Protection Act. And the response is, upon careful review of the provisions of Section 2.2 of the Child Care and Protection Act, which specifies the factors to be taken into account in determining the best interests of the child, it is noted that the provisions are tailored to protect children, and it does not appear that these provisions can be modified to apply to adult students who are 18 and 19 years old or older. In the circumstances, we are proposing that students of 18 years and older utilize the relevant laws available for recourse where the circumstances require.
Sounds reasonable if those below 18 years are protected under the Child Care and Protection Act. That's what is applicable. And any offense in relation to those over and above 18 but are in fact students, other legislations would apply. So that's clear.
I agree. Members, we accept that? Yes, so moved. Please carry on, Ms. Gordon-Jones.
Yes, Minister, I accept that.
Number 4 says the redraft of clause 24 was deferred to the technical team for further consideration. In section 20, clause 24, you would note based on the inserts indicated in red. If I read the original version, it says 24.1, a person shall not practice as a teacher unless A, the person is a licensed teacher, or B, the person is an instructor. 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000. 3 was what was proposed after. So the current amendment, if you look on the document that with the items for finalization, it says at 1A, the person is granted, the word granted is inserted, a license to teach, or B, the person has been granted an authorization to teach. So those were the insertions.
Just jogging my memory, the persons who would be granted the authorization to teach would have been the person that was outside of the system and seeking to return?
Chair, I think I need to read all the clauses under that provision because the current 24 under the bill is just 24.1 and 2. And now this new draft is 24.1 through 2, 7. Based on my recollection, I think there was some agreement with the what is currently there, is except for the matter of the fine and so forth. So for the benefit of everyone, I'll read all the provisions. 24.1, a person shall not practice as a teacher unless A, the person is granted a license to teach, or B, the person has been granted an authorization to teach. 2, where the council is satisfied that a person is practicing in contravention of subsection 1, the council shall by notice in writing direct the person to make an application for the license or authorization to teach as the case may be within 21 working days of receipt of the notification of the contravention. Where a person under subsection 2 does not comply with the direction within the specified time under that subsection, the council shall by notice in writing give the person another 21 working days in which to make an application for the license or authorization to teach as the case may be. 4, where a person under subsection 3 does not comply with the direction within the time specified under that subsection, the council shall by notice in writing direct the person to forthwith cease to practice as a teacher. 5, a copy of the notice under subsection 4 shall be served on the principal of the institution at which that person is practicing as a teacher or the employer of the person as the case may be, and upon receipt of said notice, the principal or the employer shall with forthwith ensure that the person who is the subject of the notice ceases to practice as a teacher until that person produces evidence that he or she has been granted a license or an authorization to teach. 6, a person who does not comply with a direction under subsection 3 or 4 within the time specified thereunder commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000. 7, a principal who does not comply with a direction under subsection 5 in the time specified thereunder shall be subject to an inquiry on the part 8 by the Professional Practice and Conduct Committee. 8, an employer under subsection 5 who does not comply with a direction under that subsection in the time specified thereunder commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000.
Members? Any question? Do you have a question?
Question. So this particular section is treating with to ensure that the person who wishes to teach is certified by being granted the license. And then it went on to say if the council is satisfied that the person does not possess the license, that individual now has 21 days in which to pursue such. And if after that 21 days, the council is not in receipt of such evidence, there's an additional 21 days. And then it went on to state that you give notice in writing for the person to forthwith cease to practice as a teacher. So you can't practice as a teacher. And it provides some obligation on the part of the employer to ensure that they must apply with the instructions given by the council. Now, question I'm asking is that if you are, in this case, being expelled from teaching because you don't have the license, why is there the need to to be treated as a convict under summary conviction in the parish court for a fine not exceeding an amount. Because you can't teach unless you have the license. And you would be expelled from teaching because after the first 21 days and the second 21 days, you have not satisfied the requirement. Then you are out. You can't teach. You shouldn't come in. And there is no other opportunity after that being suggested that you can take remedial steps after the first 21 and the second 21. So why is there the need now to pursue conviction?
Mr. Foreman, go ahead. But it wouldn't be the principal though, whoever hires you. No?
No,
Both of them,
it's both of them.
All right.
I can understand the principal who would continue to have that teacher still being employed because there's an obligation if the council indicates in writing and provide notice as to the employer that the teacher can't teach because the teacher would not have satisfied the requirement, then the principal must take steps. So the failure of the principal taking steps to continue to expose that teacher to students who does not have in their possession the license, then that's another story. But if the teacher now, well, how the teacher going to continue? So you're holding.
I want it on record.
Yeah, you're holding both committed to taking the steps.
Correct.
Okay.
All right. So it's the principal and the teacher.
All right.
Okay.
I will look at it again.
All right, Mr. Foreman, please go ahead.
Sorry. Hi, good morning, Chair. Thank you. I have 2 or 3 comments in relation to subclause 6. A person who does not comply with a direction under subsection 3 or 4 within the time specified commits an offense. Subsection 3 is part of the notification process. So it's the added time given to the person to apply. I'm curious for the rationale of making that an offense. I can understand subsection 4 being an offense because subsection 4 deals with the directive being given directly to the teacher to cease practicing. That I also wonder why that might be needed if the teacher can't practice in the first place without having the correct authorization. The other question I'd raise is in relation to the what I describe as a disparity of treatment between the principal who does not comply with a direction and the employer who does not comply with the direction. In relation to the principal, they are subject to a disciplinary inquiry, whereas the employer is subject to a criminal offense. Those 2 things are very different in terms of the severity of the actions, and I'm concerned about whether that the justification for treating them in that way. And thirdly, I'll also have a question about the rationale for placing the directive on the principal to tell the teacher to stop teaching instead of placing that on the board. The general scheme of the legislation has been to refer to the board of an educational institution or the employer, and that comparison made sense to me because in both instances, it's the board that employs the teacher. And in the case of non-public institutions, it's the employer with whom the teacher has that relationship. So this provision strikes me on the face of it as a departure from that consistency. And I'm interested in understanding why that is so. Those are my questions. Thank you.
Thank you, Mr. Foreman, for those observations. In relation to your first, with reference to subclause 3 or 4, I saw it when I read it, and I do concur that only subclause 4 would be where the comments would be committed. In relation to the disparity with the penalty for under subclause 7 and 8, I think the thinking behind it was the fact that the principal of a school is the one who is responsible for the operations, and so you would know at subclause 5, we indicated the principal of an institution or an employer, because we are noting that under the bill, you can have an employer who is not an institution or be governed by a board. It can be an individual. And so those employers who would have the principal being the head of the institution, then they would be able to be subject to discipline by the professional practice and conduct committee. However, if you are, for example, a single employer or so, you would be fined. So I think that was the thinking behind it, and so we are open to whatever changes if it is not a suitable clause to use in the bill.
So, yes, there are some institutions that the principal might be the owner of. Or you have those that you have a board, in this case, the employer. This is saying the principal or the employer. Now, is it selecting that the principal must act or the employer must act? Or does it binds both to act? The or here, in my mind, can suggest that either have the propensity to do so. So if the principal don't act, but the principal says the board should have acted, I'm just a little uncomfortable with the or separating the two. When it seems that board should be obligated to act and the employer, the principal and the board. But if it says or, it may suggest that the board can say is the principal, or the principal can say is the board.
Principal, if you note at subclause 5, principal is tied to an institution. So that institution would have a board of management. So it would be the principal being the chief executive officer of the board that would be responsible to take the action. Right. But in terms of when we say employer, because as I said, you can have a parent who is an employer. So It was along those lines that we made those differentiation.
In the case where you have the principal and the board, upon receipt of said notice, the principal or the employer shall forthwith ensure that the person who is subject of the notice cease to practice as a teacher. And I was referring to where you had the principal or the employer. Wouldn't it be better if you have the principal and the employer? In other words, you're binding both to the action. I mean, if it was intended to be scripted this way to achieve the objective, my only concern is that one can blame the other that the other didn't act.
Thank you. In relation to five, the whole idea about putting principal and employer was to deal with the instance where you have an educational institution with a board. So principal would cover that, and then employer would be different, where you don't have a board. For example, persons who are homeschooling and so on. Now, if we want to bring in the board and make the board, give the board some responsibility where this is concerned, we could amend the provision to include the board and say, for example, in the case of an educational institution, the principal and the board, or the principal and the employer, and then in the instance where it's an independent situation, homeschooling or so on, then you would have the employer. However, you would then have the challenge of how do you make the board accountable further down? That is something that we'd have to hammer out.
I now understand the distinction that you're making with the principal on the one hand, and when you say or, the employer being a parent having a school at homeschooling. So it's now clear for me. But how it read in the first instance, it gave the impression in my mind, certainly, that you are placing an emphasis on a principal on the one hand, or an employer and an employer being the board. At 6, we're taking out subsection 3. So where Mr. Foreman now asked that under 7, the principal of the school is exposed to a professional, an inquiry. And 8 now, an employer under subsection 5 who does not comply with the direction under subsection 7. So the homeschool practitioner is the person now who is the employer in this case. Under the definition, in relation to a teacher or instructor means a person who engages, employs, appoints, or has the authority to direct a teacher or instructor. Does this authority to direct include the board? Under the definition of employer.
For those persons online, our legal team is in debate about this question that Member Gale raised.
Sorry, Chair, may I?
Please go ahead, Mr. Foreman.
Yes, I just want to add more to my curiosity about the distinction between the principal and the employer. I mean, one, in the first instance, when we look at the definition of employer in the bill, it says in relation to a teacher or instructor means the person who engages, employs, appoints, or has the authority to direct a teacher or instructor to teach or practice as a teacher, as the case may be under this act. So that actually covers, you know, whether it's private sector, public sector, doesn't matter. And then, and it would include a principal, presumably. And then if you look, for example, at the existing, well, I think the numbering may have changed, but you know, there's a provision in the bill that places a duty on employers to notify the council if you know, they dismiss a teacher or instructor, or if the teacher or instructor resigns in circumstances where that person might have been exposed to some sort of disciplinary sanction under the legislation, that the employer has a duty to inform the council of those actions. So that particular provision is an example of the existing scheme of the bill, treating the person who has direction or control over the teacher or instructor to act in a particular way. So this new draft creates a different type of scenario that is a bit curious. And I've heard the response to the inquiry about the difference in treatment between the principal who doesn't act pursuant to the notification and the employer who doesn't act pursuant to the notification. As I've said, there may be a case to say that the principal might also be an employer, given how the word employer is defined in the bill. But more importantly, I think my office is not quite persuaded that treating the same action, i.e. in this case, a failure to prevent the teacher from continuing to teach until they're regularized, treating that failure in two vastly different ways can be justified. Again, you know, there's a very significant difference between somebody being subject to potentially a disciplinary sanction, an administrative disciplinary sanction, and a person being exposed to a criminal conviction. Very different things. So that if the policy is that there's a need to sanction an employer for failure to prevent the teacher from continuing to teach without being regularized, the sanction needs to be the same. So those are my two further comments at the moment.
Chair, I listened to my learned friend, and I agree with what he's saying. Normally in the bill, when we use employer, it would normally say other employer based on the definition of the term employer in the bill. And so this provision as it is will create some confusion in terms of just using employer based on the definition. My issue is, how do we treat with the institution or the employer, just say the employer, who does not comply with the notice issued by the council, bearing in mind that the employer can be a board or a parent or a group of parents.
Good morning, Chair members. Chair,
Please go ahead, SG.
thank you. Morning. Are there any other examples in the bill where an employer can be sanctioned? And just to clarify, our issue wasn't about employer or other employer. Our issue was taking out principal and dealing with the principal separate from other employers because you have not done that otherwise in the bill. That's the distinction we wanted to highlight. But can you just? I can't find examples of sanctions for employers. I just wanted to see how the bill has otherwise dealt with sanctions for employers, because perhaps that could give guidance here.
Chair, I cannot recall any provision in the bill that treats with the sanctioning of the employer.
So SG, do you have a response? Mrs. Gordon-Jones was just said that she is not seeing any instance. All right, Ms. Gordon-Jones, in which, what's it, yeah.
Sorry, Chair, I didn't hear that clearly.
Okay, Ms. Gordon-Jones, can you repeat?
I was just indicating, SG, that I cannot recall any provision under the bill which treats with the sanction of an employer.
And that is also my recollection. So why is it being done here? And there's a reason for that, because if you look at the definition of employer, who falls under the definition of an employer, it would have made it very difficult to do this sanction. So I think, and then the issue is why here you're going to put a sanction, criminal sanction, and elsewhere in the bill you don't. How do you explain that?
Yeah, I think so as you know, that provision was not there, but I think the discussion of the committee at the time was to provide, I think they were saying that if you don't act, how are you held accountable? And it was on that premise, we had to try and find a workaround, but obviously the workaround is not workable.
Well, I guess maybe the bigger issue we had was trying to split out principal from the other employers and then treating them vastly different. And there is a constitutional protection about equal protection before the law. So a law, if you're going to make big distinctions, you really have to justify it. And you'd have to meet the constitutional test. And as Mr. Foreman explained, it's two vastly different types of penalties.
to deal with basically the same person because the principal does fall under the definition of employer. But I think looking back at the scheme of the bill, because you see, you can't always just treat one section independently. It falls in a scheme. It's very curious that you are going to apply a sanction for this, for failing to act in this provision, but yet when the employers fail to act otherwise, there is no sanction. There really has to be an explanation for that as well.
We're not hearing.
And Mr. Foreman, my apologies. I was just thinking out aloud.
Oh, I see. Okay, thank you.
Yeah. But I go back and I'm trying to jog my memory, Mr. Foreman, in terms of why the concern would have presented itself. Under the original 24, it gave a person shall not practice as a teacher unless the person is a licensed teacher or an instructor. And then it went on to place that a person who contravenes subsection 1 commits an offense and is liable, which would have placed the burden only on the teacher in this case. And I recall where the committee would have suggested, but you could have had a teacher being part of an institution, don't have the license, but was teaching. And how you treat with the employer in this case for the purposes of accountability. And I believe this drafting would have been the possible response to those concerns of having dual accountability being placed on both the teacher and the institution. Yeah? Now, I understand quite clearly that in imposing a sanction of discipline, where in this case, the same offense with different accountability, but a different outcome. In that, in the first instance, the principal would be treated with under an administrative rule, but then the employer will be treated with a criminal offense. And so balancing justice is important. But we were trying to, if I recall, the committee trying to hold both accountable for the opportunity to practice without a license. And that was the intended objective. So I don't know if my express thought now on record would make it any clearer in terms of the intent at the time.
Yes, remember, in relation to the intent at the time, yes, and my recollection of the discussion, now that you've articulated it, is similar. I mean, that doesn't advance the point just yet, but it gives us
it doesn't change the outcome of where we are now.
But yes, the point is taken. I mean, I'm trying to. I mean, I don't recall if under any other of the professional schemes that we have, doctors, nurses, lawyers, etc., with a similar type of concern is addressed there. Hiring somebody as a nurse or as a teacher, as a nurse or as a lawyer or as a doctor or as an engineer, knowing that they don't have a license. My sense is that the duty is normally placed on the person who is trying to benefit from being in the profession and to have themselves regularized. And there may well be an assumption that exposure to sanction would be enough to compel the person to stop doing whatever they're doing. And that a person in that situation, even if, let's say, you have an errant employer who wants them to continue teaching, would be wise enough to until they've regularized themselves. But as I've said, in terms of a fix, what exists now, we can pretty confidently say we're not comfortable with it. Whether there's an option that can address the concern that was raised would need some consideration, I would suppose.
So under the original 24, it places the burden on the teacher to provide the evidence of the license. And that's the policy direction of the legislation. And if the person contravenes that under the original, then they face conviction. How does, in terms of process, because what the redraft is suggesting in the first instance is that if the council becomes aware and the council notifies the institution, then the institution must act. Right? That is not said in the original draft. So the redraft provides an expansion in terms of process. Where do we have the challenge now? How you treat with the principal as opposed to the employer in terms of sanction. Because there's a consequential action if the institution is notified by the council that the institution must act. And the institution does act. But the redraft now is applying sanctions if both don't act. And it's not identical sanctions. And I think that is where we would have the challenge. Right, Mr. Foreman?
Yes, Senator, that's the challenge, finding if the intention is to apply some sort of sanction, one has to think through how that is to be applied, bearing in mind that an employer can range in personhood, right? It could be the school board, it could be a private company that maybe hires somebody, it could be a natural person who hires people, range of different circumstances.
Go ahead, Dr. Gordon.
Morning, members, colleagues. I'm sorry to be late. Let me apologize. I recall this discussion very well, and I have the notes here in my draft act, that at first we said only the teachers would be fined for the practice, for practicing without the requirements. And then it was brought to attention that if you're really going to make the change we want to make to the profession, both the teacher and the person who employs the teacher must be responsible and accountable for the practice of the teacher, and that they must make themselves, the employer, aware that the teacher is suitably qualified and is professionally prepared for practice. It cannot be the teacher only, or else that administratively is going to be a challenge to manage. So the person who employs the teacher must take responsibility, or must be accountable, must be sure that the person who is being employed should be employed to practice in the institution or to practice with the child. We cannot leave it to the teacher alone, and then the council must find out. The employer must take some responsibility to ensure that the person who he or she is employing is suitable for practice in education. Thank you, Chair.
What did they do?
Mr. Foreman. So in the medical profession, it requires licensing.
Yes.
Right, and also in the legal profession. Is there a way of treating with it? Let's use the medical profession. Is there a way of treating with an instance of this nature?
Right. I'm not aware.
Not aware.
I said I'd have to look at the various legislation, but I'm fairly confident at this point in saying that the remedy, so to speak, is directed against the person who is holding themselves out as or
Accountable.
practicing without having the requisite certification.
So the burden is essentially placed on the individual.
Right. In terms of sanction, yes. And you can have a statutory obligation without necessarily having a sanction attached to it. I mean, that's not impossible.
So, go ahead.
Thank you, Chair, and sorry for being late. I'm listening to Mr. Foreman, and I'm not sure I'm able to disagree with him this time, because the two sanctions can't be different. And I know it's difficult to figure out a way to sanction the employer, and I understand the motive behind it, because if we want to sanction the teacher, there's a responsibility for those who hire that individual without the certification to ensure that this person actually had the certification. So I agree that we want to put some kind of onus on the employer and the principal to ensure that those who are teaching our children are properly certified and licensed. But I can't envision a way in which the employer can be sanctioned. I mean, I think where we go up to notifying them that the person needs to, within 21 days, get licensed, I think that's all as far as we can go. I don't know that we should go any further than that. I really do agree that the owner should be on that individual who is teaching without the requisite requirements as per law. So I think I'm siding with Mr. Foreman on this one, Minister or Chair.
Minister, if the registration of teachers is any example to go by, in the Education Act requires all teachers to be registered before they go before the classroom. We are still trying to get that act to work. And if that is any example for us to go by, then in making this decision, the employer has to be held accountable. Because the one-sided affair where the teacher has to be registered, the teacher ought to be registered. And the employer, it doesn't matter, employer can employ an unregistered teacher. It's not working. And this is from 1965. So if we are making an act that we want to be effective, then both the employer and the teacher must be accountable for the professional standing of the teacher.
But then, Chair, I agree with you. You want to make this law as strong as it possibly can be, but you can't have two different sanctions, because if it is the principal goes through, they're investigated, essentially, whereas the employer is fined. There's a fine for the employer. So unless you're going to have the same sanction for the teacher, for the principal, the teacher, and the employer, then I could support you. But with the various sanctions, I'm not in agreement with varying sanctions. It has to be one. So it's either we're going to do one that is the same across all, or we're only going to sanction the teacher who is not licensed. It's one or the other.
Sure, I'll go a little further in terms of the sanction. As you know, the appointment of a teacher in relation to a public educational institution is the responsibility of the board, but then it goes to the Ministry of Education and Youth for confirmation. And so if the board sanctions that appointment of that person who is not licensed to teach, and it sends it to the ministry for confirmation, it means that the ministry would also be a part of that. So the portfolio ministry for the bill.
Sorry, a question needs to be inserted in that process that says, do you have your documents? Yes.
You know, the conversation is going back to the original draft. It's just that two in the original draft would suggest that if the person commits the offense, what will happen? But how you pass, so you're thinking that the person must not pass the gate without the license. Mustn't come through the school gate and enter the classroom without the license. So what we're anchoring it on in the original draft is that if someone escapes that, and then the burden is placed on that individual. Not the checks and balance that should have been ensured that the person don't enter the classroom. Because the original draft never contemplated in its drafting any process of checks and balance. It just assumes that you must have the license, and if you don't have the license, you face the wrath of the court. So if we're going to stick to the original draft, it is upon when it is identifiable that the person would be teaching without having the license. So are we going to go back to the original draft?
The more formal setting of, for example, that of a school, you have your checks and balance in place to ensure that these documents are presented in order to be employed. However, what of homeschool situation where the parent wants someone to teach, and he said, oh, I don't have my license, but I still can do it, and that person decides to employ the person nonetheless. So in terms of the more formal setting for the schools, it is more preventative, but a single employer, like a parent or so, it might be a more difficult situation for them to have those checks and balances
That
in
teacher
place.
might be cheaper too.
Exactly. So I think it still goes back to just finding the teacher, because it is going to be difficult, in my opinion, to treat with the situation based on the various employers that you have.
Madam Chair, the database of licensed teachers, like the database of registered teachers now, is available. A principal, board, or board members, board chair will have access to that information. There's a database now and the principals will have codes, they'll have access to the database, so they can verify for themselves if the teacher is a licensed teacher. Parents can access the public documents. The Gazette. Parents can access the document. They can know if a teacher is registered or is not registered, if a teacher is licensed or not licensed. It is a public document, and it's a requirement in law. Just like the register of surveyors of the register of doctors. You know it's a public document, so it is up to the board or the principal to verify that the teacher is appropriately licensed or registered and licensed.
Go ahead, Mr. Foreman.
Sorry, thank you, Chair. Just in response to Dr. Gordon's comment there, I take it that a slight difference between what exists now and what will exist when the bill is made into an act is that there isn't really a sanction that can be imposed on an unregistered or unlicensed teacher in the existing scheme of things. Whereas when this act comes into effect, the person who teaches without the requisite authorization will be exposed to criminal sanction for failing to do so. And that might create a vastly different scenario to what now exists. So I'll add that to the mix for the committee's deliberation.
I'm sorry, Mr. Foreman, sorry, I know you went through that, but if you could just repeat the part at which you said when this act comes into effect, you're trying to simulate in our minds the environment that will exist then.
Yeah, I'm trying to suggest that perhaps one of the reasons the existing arrangements are not as effective is that you don't have a regime for sanctioning a teacher who is not registered or licensed. Whereas when the act comes into effect, the failure of that person to regularize themselves will expose them to criminal sanction, as now applies with other professional organizations. And that possibility of a criminal sanction could have the effect of deterring unregistered, unlicensed persons from continuing in their ways without regularizing themselves.
Chair, what I gather Mr. Foreman is saying is that create the detriment and raise that threshold that there is going to be a punishment of a conviction if you are found to be practicing without the license. And place the burden solely on the teacher and see how it works. In other words, there is a deterrent. Don't do it. That's what I'm gathering Mr. Foreman is saying.
Does that capture it, Mr. Foreman? Mr. Foreman, does that capture what you were saying?
Sorry, Senator, could you just repeat?
No, I was saying that what you have done is to place the emphasis and the burden on the teacher. The application of the deterrent towards conviction is strong enough to ensure that a teacher would not want to run the risk of practicing without a license.
Right, that would be the argument in favor of meeting the original version of the...
Yes, the original draft.
Right, but a higher authority wishes to intervene. One moment.
Sorry? Oh.
Sorry, hi, Chairman.
This is a higher authority.
I don't know what he's talking about. He's a little delusional from time to time, but forgive him anyway. There is no higher authority. It's two things. I wouldn't say it's not just also the threat of the criminal sanction. What also acts as a deterrent is when the regulatory authority enforces the provisions of the law. So if you have weak enforcement, you're going to have a problem. We are looking at other regulatory bodies for other professions, and we don't see anything similar. Now, I know teaching is a little different and so on, but there may be good reason for this kind of construct. I would suggest that perhaps the focus should be on one, trying to enforce the provisions to ensure that only licensed persons are teaching, and that would be on the regulatory body to ensure that the licensed teachers are teaching. And if that is not the case, the regulatory body must take action. It's enforcement that really acts as the deterrent. It's not so much just the threat of a sanction. And we all see this, Senator, we are also in other meetings where we are increasing penalties and so on, but sometimes the issue isn't so much a penalty, sometimes the issue is more enforcement. And so I really just want to bring that point out. And at this time, perhaps there should be some more focus on that other aspect. Recall also that there is a provision in the bill that the act is to be reviewed by a Joint Select Committee of Parliament within, I think it's a 5-year, I can't recall if the committee has said any changes are to be made, but currently in the bill it's 5 years. I would suggest, you perhaps consider going with a provision where you focus on the teacher, where the committee will encourage the regulatory body to ensure that they enforce the provisions, and then you see how it works, because there will be a review.
I agree with the Solicitor General, who so happened to be the higher authority. Just a question for Dr. Gordon, though. In the application of, so the council would have some sort of a registrar and data. And so the council would be aware. And is there a check on each institution for those who are? I'm trying to ascertain now, because it might be easier in the public system or even the private schools for you to check the data. But that parent now, where that parent would be the sole and singular employer operating, that might be where you would have the challenge. Am I correct? Eh? It's just that the question of enforcement now is how you apply enforcement. Because you would first have to be aware in the first instance. If the school becomes aware, then the school can report. Yeah, I may understand the deterrence, but it's the enforceability that we need to think about in our minds as to how we can pursue the enforceability.
Chairman, we should keep in mind the map of our country. Primary schools are all over Jamaica. I don't know if you ever heard of a place called Washfoot Gully. And I could, yes, and I could tell you about a number of other ones, Ulpira, Penline Castle, all of them. I could tell you, I could list them to you. The deterrent has to be on both sides, the teacher and the employer. That is the only way we are going to ensure that all our children are taught by licensed teachers. The only way. We cannot leave the onus on the teacher alone. The employer must be a part of it. Whether it is a parent or a private school, public school employer must be a part of that accountability.
So members, are we going to take the advice of SG to say, where are my notes? Focus on the teacher. Plus the regulatory body to sanction. Act to be reviewed in 5 years.
I am in support of the higher authorities' view.
Chair, we know what we intended to pursue. It's just that we can't find the right construct and application. And you don't want to draft a legislation that has imbalances or it is unfair. And what is being put forward in the redraft would suggest that. So let's go back to what the original was and let us see how it works. And maybe whenever that review period, we would act on the data that may present itself or the eventualities that may present itself to better able to direct us, or we can find a kind of, amenable, appropriate construct.
But Member Gale, what we have in front of us does not say anything about the teacher. It just speaks to, the latest document. It just speaks to the principal and the employer. Okay.
Chair, I heard member indicating reverting to the previous draft. I think it's in relation to just finding the teacher. So we could, the committee could consider adopting this redraft and deleting 7 and 8.
So 7 and 8 brings in the dual accountability of principal and employer. But if we treat it with up to 6, taking out subsection 3 as agreed, because subsection, in relation to, 3, sorry. Subsection 3 would be that first point of notification, which ought not to carry the weight of a punishment because you're just notifying the person. Yeah.
Chair, but clause 5 would need to be reworded. And Chair, just to note that the revision of the act when promulgated is within 5 years, so it doesn't have to be 5. Or it says no later than, so it can be earlier than 5. So the redrafted provision for 5 would read, a copy of the notice under subsection 4 shall be served on the board of the educational institution or any other employer, and upon receipt of said notice, the employer shall forthwith ensure that the person who is the subject of the notice ceases to practice as a teacher until that person produces evidence that he or she has been granted a license or an authorization to teach.
Sorry, in the first instance, you use the board and the employer, but in the second instance, you only use the employer.
Chair, the drafter is indicating that we'll use the word employer only.
Okay.
So it would eliminate those additional words. And in relation to subclause 6, we'll delete the reference to subclause 3 or.
Gordon Jones, can you just read it again with the further revision?
Reread 5?
Yeah, with the further revision.
So it would say a copy of the notice under subsection 4 shall be served on the employer and crave your indulgence, I'm checking with the drafter. Subclause 5, a copy of the notice under subsection 4 shall be served on the employer, and upon receipt of said notice, the employer shall forthwith ensure that the person who is the subject of the notice, ceases to practice as a teacher until that person produces evidence that he or she has been granted a license or an authorization to teach. 6, a person who does not comply with a direction under subsection 4 within the time specified thereunder commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000. That would be the end of clause 24.
So we'll be Xing out 7 and 8. Okay. Okay. Members, we concur? Yes. Aye.
So, sorry. Just may I, Chair?
Go ahead, Mr. Foreman.
Just a small matter. The obligation under subsection 4 is to sorry, I'm working this through as we go along. So subsection 3 places an obligation on the person to apply for the license or authorization to teach. Then subsection 4 says that if that person does not comply with the obligation to apply for the license or authorization to teach, a duty is placed on the council to direct the person to cease to practice as a teacher. And then subsection 5 says, then the next subsection is going to say that the principal employer. Sorry, I'm trying to ensure that the sanction is placed on the person continuing to practice as a teacher and not simply on the person failing to apply for the authorization to be permitted to practice as a teacher. Perhaps when the next draft is prepared, I can just properly address my mind to the change that was made. But let me just flag that at the moment as something that I'll be commenting on when we see the.
So, Mr. Foreman, so the person is required in 24:1 that they shall not practice without the license. And then if the council now identifies in 2, is satisfied that the person is not practicing, the council gives them the first 21 days to get the license. Then in 3 now, where the person does not comply, then there's an additional 21 days. 4 now, where a person under 3 does not comply, then the council now shall give notice in writing that they must cease. And then 5 speaks to providing the notice now to the employer at which the person is practicing as a teacher. So this is where in 4 they should cease. And in 5, this is where the emphasis is now placed on the employer to ensure that the person who is the subject of the notice must see. So the action now is applied in 5 on the employer. And then 6 now goes back to 4. It goes back now to the teacher to say the teacher would be liable for an offense. So in my mind, there are some different layers and applications.
Yes, and the duty under 4, if I may just piggyback on that process, the duty under 4 is to apply for the license or authorization. Right?
The duty under 4, where a person under subsection 3 does not comply within the specified time. This is where the council must say now to that person, you need to leave the schoolyard because you don't have the license. So the action in this part, in my mind, is on the council to act in 4 in relation to the provision of failure under 3, which would have been the second 21 days. And that notice now, under 5, is given by the council to the employer. Drafter, Ms.
Yeah, my nutshell point, I think, is that we should ensure that there is in fact a duty on the person who is practicing without the requisite authorization or license to stop doing so and ensure that there's a clear provision that says if you don't stop doing so, you are liable to a criminal sanction. I think the drafter can take it from there.
So would 6 deal with that? No, he's saying that the obligation, has to be a connection within the provisions of subsection 4 and what in my mind is subsection 6. But 6 makes reference to subsection, the actions of subsection 4. No, we're taking out subsection 3 out of 6. Because, oh no, sorry, hold on. Oh, no. We're taking out 3 of 4, and 3 and 4 remains in 6. Right. Three out of subclass 6.
So it's only on the second notice?
Right.
Only on the second 21-day period that you're liable for this.
Mr. Foreman, can you please repeat what you alluded to in relation to what the drafter was supposed to take note?
Right. I'm just saying that we should ensure that there's in fact a sanction for somebody who continues to practice as a teacher without having the authorization or license. The provisions at the moment read as if they applied to not applying for the authorization or license. But my sense is that there's a gap insofar as there's nothing to say that the person who continues to teach without the requisite license or authorization commits an offense in doing so, right? So it's pretty clear that there's an obligation to apply to get onto the system. It's not clear to me that there is a prohibition on continuing to practice as a teacher without having the license or authorization.
I appreciate what my learned friend is saying, because the previous provision said that if the person contravenes subsection 1, and subsection 1 speaks to, in 24, speaks to practicing without the license or authorization to teach. So the revised draft for subclause 6, not sure if this would remedy it, Mr. Foreman, but it would read, a person who does not comply with a direction under subsection 4 and continues to teach without a license or authorization to teach commits an offense and is liable on summary conviction in the parish court to a fine not exceeding $500,000. There was no specified time. There's no specified time under subclass 4. So the specified time was really in relation to subclass 3. Subclass 4 says forthwith. Subclass 4, sorry, says forthwith.
Connection now with what you're saying in the redraft of 6 that does not have within this time specified. It says, read your new 6 for me. A person who does not comply with the direction under subsection 4. Now, I believe you would have departed within the specified time thereunder.
I'm going to read the revised draft once more. A person who does not comply with a direction under subsection 4 to cease practicing as a teacher and continues to teach without a license or an authorization to teach commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000.
That would mean if that person leaves the institution and goes somewhere else and continue the behavior.
I would think.
Are you trying to capture both? Because you could have both situations. You could have that the person continues, don't cease at the institution and continues to ply their trade somewhere else, if given the opportunity.
That, but I don't think the seizure is in relation to that particular institution.
The seizure is also stop teach.
General seizure.
Stop teach. Mm-hmm. Put on the chalk on the chalkboard. Right, Dr. Gordon? So if that's the intent, it's an overall coverage that the person must have cease and desist. You don't have the right to. You don't have a license.
Mr. Foreman, is that does that clause satisfy your concern with that was raised earlier? Or you would want to see the actual draft?
Thank you. Yes, the latter.
Very well. We will have it circulated, including to the committee members.
And just to emphasize, my concern is just to ensure that we are prohibiting the person from continuing to practice without having the requisite license. I just need to ensure that a gap isn't there. Right? Person might the statute doesn't say I must stop teaching. Right? Those niceties might arise in the absence of clear language.
All right, looks like we're at a point now where we will move on to any other business. What do we have? What's the other one? So,
I did not already.
okay. All right. We wish we could continue, but we have to stop. Yes. And so for the next meeting, we will seek to complete these amendments. I think we only have one section left, and the disqualifying offenses. We'll also seek to confirm the minutes at that time as well. Oh, okay. Oh, we needed someone to second the minutes. Yeah, all right. Of October 5th. So member, yeah. Okay, so we're good there. So the date of the next meeting is December 13 at 10 a.m. If a date opens up before that, then we will advise members. All right. Thank you so much, everyone. Yes, Mr. Nash tells me that he'll be coming with a report at that time. Yes. Well, I mean, I'm sure the last page you can modify. You can add the last page to the report after that meeting. But, right, after that meeting, you can add the last page, but we'll have a 99% completed report.
Hopefully, there's no additional deliberations that are extensive.
Yeah. No, but at least you can give us the report so we start reading. Yep, the draft report. All right, thank you so much, members. See you on December 13th, if not before, at 10 a.m. And please look at the list of
Chair?
offenses for the next meeting. Please go ahead, SG.
Hi, thanks. Just in terms of the report, please note that a part of the report, an important part, are the proposed amendments. So the report can't be finalized until the amendments are settled. Just a reminder.
No, it will be a draft report, SG, so that we start reading.
Yes, I understand. So my issue isn't that. I'm just saying the report can't be settled without the amendments being settled. That's the
Right.
only point I'm making.
Yes.
Yeah, thanks,
Absolutely.
Chair.
Thank you. All right, have a good day, everyone. Thank you again.